Hello, my name is Hilary Gerjoy, and I am a partner at Harris Wilshire and Grannis. I am the vice chair of the firm's legal ethics and malpractice group. I principally represent lawyers and law firms in disciplinary investigations and prosecutions, and I've handled matters in front of a number of state bars, including the Attorney Grievance Commission of Maryland and DC's Board on Professional Responsibility. I'm also a member of the DC Bar Rules of Professional Conduct Review Committee, which is the committee that reviews the rules of professional conduct for possible revision and amendment. And I teach legal ethics and professional responsibility at Georgetown Law School. Today, I'm going to be presenting on the ethics of cybersecurity, and I'm going to go through a number of the legal ethics rules that are implicated by cybersecurity, and then some case studies about opinions that have come out in which courts have ruled on what lawyers were supposed to do with respect to cybersecurity. So I'll go into the agenda now. The first two sections of the presentation for today will talk about competence, which is Rule 1.1. And so the first section will talk about technological know-how and the requirement and burden that the rules of professional conduct put on lawyers with respect to understanding technology. Then I'll move into some competence case studies involving social media, e-discovery, and metadata, and specific requirements that are imposed in terms of understanding and being competent with respect to those pieces of cybersecurity. I'm then going to go into confidentiality and what the standard for reasonable care is under the rules, and the nuance that exists about how you have to keep information confidential and what that looks like in a world in which information is stored in the cloud and can be stored in multiple places, and people are no longer relying just on paper files. Then I'm going to talk about specifically requirements related to storing data in the cloud, and that's really where the competence rules and the confidentiality rules meet. Then I'll go into the communication responsibilities that lawyers have, particularly with respect to communicating data breaches to clients. And then finally, I'm going to go through the requirements that are imposed on lawyers for supervising those who report to them to make sure that they too are being compliant with all of the rules of professional conduct. So ABA Rule 1.1 states that a lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. In Comment 8 to ABA Rule 1.1, and I'll note that every jurisdiction has a Rule 1.1 that mirrors this, but Comment 8 is specific to the ABA. Not every jurisdiction has adopted this particular comment, which says that to maintain the requisite knowledge and skill, a lawyer should keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology, engage in continuing study and education, and comply with all the continuing legal education requirements to which a lawyer is subject. The particular important thing to note here is the ABA's requirement that lawyers stay abreast of changes in relevant technology, particularly with respect to the benefits and risks associated with technology. The impetus behind this particular comment is really because confidentiality is so significant and important, and because a lawyer needs to be able to maintain client confidences and communicate effectively with clients, that part of the competence obligation, the 1.1 competence requirement, is really that a lawyer understands the uses of technology and how they can aid in their particular practice, but also how the risks associated with technology, particularly storing information, and how there are confidentiality concerns, communication concerns, lots of different rules that are implicated, and the threshold is really that you know enough about technology that you're able to meaningfully represent your clients in an effective way with respect to all parts of the representation. In Opinion 371 that came out of DC, and this was an opinion in 2016. The DC Ethics Legal Ethics Committee, which is the committee that writes opinions to basically explain the contours of the rule, stated that because of society's embrace of technology, a lawyer's ignorance or disregard of it presents a risk of ethical misconduct.